Hey, good afternoon. It is your Adult in the Room, Victoria Taft, on the Adult in the Room podcast live stream on a Thursday. Usually it's Epstein Thursday. However, what we are doing today is talking with Richard Epstein, who's an eminent expert, constitutional law scholar, one of the certified smart guys in the entire country on the issue of the 14th Amendment and whether it really does accord birthright citizenship to people who come into the country illegally or who never expected to be in this country and just find themselves there by happenstance. And they dump a baby, I put it very terribly, then does that baby become a U.S. citizen? Well, some people think so. That's the way we've been operating for a very long time. We'll talk to him coming up later about his new book about the 14th Amendment. He is a person, I mean, I'm just intimidated. Okay, it's okay. Of course, the last 24 hours, we've seen a lot of news having to do with what the left has been doing by sort of stacking the deck against their political opponents on the right by making stuff up. Yeah, it's pretty astonishing. And I have to say that it's, if you don't know the left, if you haven't been watching the left and this arrogation of power, especially following the Virginia election this week, then you need to get your learn on. And I'm so glad you're here today. So by all means, chime in on the comments section. Be nice, please. I mean, no ad hominems and no crazy stuff. But I'd appreciate it. And get your questions lined up for Richard Epstein coming up later in the program. Okay, the Southern Poverty Law Center, a once meritorious organization, has been accused in an 11-count federal indictment of creating the racism it said it was working to destroy. Creating it. Now, remember, you heard that, and you may be thinking, oh, come on, Victoria. No, I do not stutter. The SPLC, Southern Poverty Law Center, literally paid for the hate, not all of it, but enough to make you go, oh, wait, what is going on here? They literally paid for the hate. It then fundraised off of. It is payoff in a money laundering operation, according to the DOJ. I'm not just making this up. Then after that, they produced fake news, which resulted in more censorship of people on the right because they claimed that's where all this racism was coming from. And don't you know, white males are the biggest terror problem we have in this country. And of course, that's what we were sold in the last 4 years of the Biden administration and how terrible people are. And there are plenty of ramifications as a result of that nonsense. Lots of them, as a matter of fact. So due to there being a dearth of this naturally occurring hate, which they says is everywhere, they had to pay to create it. They had to pay for it. Rinse, repeat. And the people it hired to, in at least one case, break the law. Hey, psst. Hey, you buddy, over here. We're going to go over the indictment. Just hang in there. You'll see it all. And hey, buddy, come on over here. Oh, wait, listen. Can you start a riot? Can you do something? Can you do a break-in for us? And we're going to steal some documents from this organization. Shh. Yeah. And then when you'll hear, it's crazy. So they paid members of the Nazi Party. They paid some of the leaders of these organizations. The American National Socialist Party. That's the Nazis. For those of you who love a particular movie, Inglourious Bastards. They paid the KKK, the other racist organizations, and they paid them to do something dirty so that they could report on it and fundraise off it. And their paid hate mongers helped create the riot in Charlottesville. Now, that is what it appears to be. They had a guy who was paid $270,000 to bring in people for the Charlottesville riot in 2017. And I don't know if you remember this because we're going to go into this. We're going to listen to a little bit of a phone call of a woman who called in to a friend's show, and she talked about when the buses arrived She was having lunch in a diner in Charlottesville. Everything was peaceful and serene. And then the people in the buses showed up. So the very fine people on both sides, hoax arose from the riot by Antifa. Antifa was there, and a lot of people didn't know because they weren't really savvy about it. Oh, but we knew. Oh, yes, we did. And then, of course, there were remember the Tiki Torch dudes? The Richard Spencers of the world, that socialist? Yeah, that guy. So he was there with his buddies, and they were all wearing their uniforms. I mean, it was just ridiculous. You knew it was an information op. I remember seeing the Tiki Torches going, what the hell is going on? Excuse my language, people. It is outrageous. And it's beyond me telling you the word outrageous. I'm going to show you, and you will yourselves become much better educated about this. So, did the SPLC bankroll both sides of this violent mob? Well, it looks like it. So more on that in a bit. The very people they paid to create more hate, the very people they did was used to be the poster boys for getting more donations under the guise of getting rid of these people. Capiche? Don't worry, we'll go over the 14-page indictment because it reads like a doggone graphic novel. It is freaking believable. And they were paying people, and they were paying with gift cards. That is a favorite tool of the Share Blue money laundering outfit. Fake companies about which they lied to banks, so you can't do that. That's a federal felony. And then they committed wire fraud. This is according to this indictment handed up yesterday, which is what was yesterday was Wednesday. So that information was used to lie to the American people about white men. Look, I hate to single out, specific cultural groups or color groups, but this is what they were doing during the Biden administration. You cannot deny it. It was happening. It was just ridiculous. And we were told that the white men were the biggest risk to America, which might have been true had they been referring to Antifa, but it wasn't. They were referring to people on the right, people who went to school board meetings, who belonged to the Catholic faith, men in college, the military, Charlie Kirk and other Christians like him, and on and on and on it went. And oh honey, did they rake in the cash, man. They raked in the money. Their donations went up 3 times. I mean, it was trebled in a matter of a couple of years. And that's what happened when they started the outrage machine for the American public. And they got millions in donations from the likes of Tim Cook of Apple and all sorts of things. So when you know that the ROI on fake outrage is quite handsome. But here's the truth. If there's real horrible racism to uncover, you don't have to pay for it to get rid of it. You don't have to make a show of it. When demand for racism outweighs supply, if you're the Southern Poverty Law Center, you buy it. That's the lesson we've learned from this episode, according to this indictment. And then after you ballyhoo it, you crank up the outrage machine, and Tim Cook gives you $1 million from Apple. I'd say it was the most despicable thing that the left has ever done, but I know too much. This is just one of many in the last, 2 months that we found out. I mean, when you've tried to coup the president of the United States with absolute lies, that's pretty outrageous too. But of course, now after they targeted Charlie Cook, that's a political expert. Charlie Kirk is the guy who got murdered by the crackpot because he was put on one of the reasons was he was just so diminished. And he was said to have been a terrible hater of people in the LGBT community, BT, XY, Two-Spirit, whatever, community. That he was a Christian and he was hated women and he was a white supremacist. That's what they said. And then 4 months later, he was dead. That's already happened with the Southern Poverty Law Center. It was their hate map, after all, that got somebody to go into the Family Research Council in Washington, D.C., a Christian organization run by Tony Perkins, and start shooting up the place. He got overwhelmed before he did, and there was a security guard who got hurt as a result. But he brought in, remember this? He brought in Chick-fil-A, because Chick-fil-A is run by Christians. So it was a guy confused, clearly mentally disturbed, obviously, and clearly stupid enough to listen to the likes of the SPLC for their talking points. So that's where we are. This has been an information op, unlike most information ops. It's just that they got so much return on investment for it that we are shocked. Just color us a little shocked. So they had a financial stake in producing hate. They didn't divulge that stake, and they lied to banks to money launder. And in addition to that, being a 501c3, 501c4, and all likelihood, I'm thinking they had C4 too. What they did was, I apologize for not looking it up. I'm sure somebody can put that in the comments, should you wish. But what they did was they lied to their donors. And that's a bozo no-no. You can't do that. Excuse me, I'm going to have some more of this stuff with the caffeine in it. So that's bad. Very, very bad. We're going to go over the 14-page indictment, so it's not that long, so don't worry about it. But here it is. We have the news conference yesterday between Todd Bush and the left's favorite guy they're trying to get rid of now, Kash Patel, the leader of the FBI, talking about this issue. Let's see if we can hear
one
it.
count of conspiracy to commit money laundering. According to the charges in the indictment, the SPLC is a nonprofit entity that purports to fight white supremacy and racial hatred by reporting on extremist groups and conducting research to inform law enforcement groups with the goal of dismantling these groups. As the indictment describes, the SPLC was not dismantling these groups. It was instead manufacturing the extremism it purports to oppose by paying sources to stoke racial hatred. The indictment describes this conduct in detail, but one troubling example is that the SPLC was paying a member of the leadership group that planned the Unite the Right protest in Charlottesville, Virginia in 2017 that resulted in the death of one person and injured dozens more. This particular person being paid by the SPLC allegedly received approximately $270,000 over the course of 8 years. In total, according to the indictment, between 2014 and 2023, SPLC paid at least $3 million to 8 individuals at least. These individuals were affiliated with the Ku Klux Klan, United Klans of America, National Socialist Movement, Aryan Nations Affiliated Sadistic Souls Motorcycle Club,
the
Nationalist Socialist Party of America, Nazis, and the American Front. Now, as the indictment lays out, after SPLC paid members of these extremist groups, it created work product that reported on these activities that the members participated in or contributed to. And to that end, it was doing the exact opposite of what it's told its donors it was doing.
Listen carefully.
Not dismantling extremism, but funding it. To carry out this scheme, SPLC created bank accounts in the name of at least 5 completely fictitious organizations that had no bona fide employees or legitimate business purpose.
You know, some people don't understand, but what you can do is you can make up names. You can have a fictitious name, DBA, for your company. This is not what that was. These were wholly made up places. They got bank accounts, took out gift cards, which is, as I said, a Share Blue kind of a thing where you can money launder through gift cards. This is where in Share Blue, which is the DNC's money donation portal through which they receive amazing amounts of money. But what has happened with that is that they've been able to launder money from foreign targets, foreign people, foreign organizations, maybe perhaps state actors, probably, I would imagine, either people working on behalf of a state actor or what have you. And they're using this, the gift card thing, to funnel money to the Democrats to mess around with American elections. And that's why they're under investigation now. And this is the sort of template, I believe, that it was used by the Southern Poverty Law Center. And here's the other thing. I kind of wonder who learned from who. The SPLC's been at this for decades, right? I mean, they've been doing stuff like this. This pertains specifically, however, to a period of time between 2015 and 2023, which is, I think, when the Biden administration gave up the ghost and did not want to go further in its investigation of the SPLC. That is exactly what you heard me say. The Biden administration started this investigation and dropped it. Now, we don't know why that occurred, except for the fact that the SPLC is one of its best friends. But the fallout of all of it is something to behold. Let's take a look. Initially, we'll go back to Todd Blanche, who is the acting attorney general. We'll do that in just a little bit. But let's take a look at this indictment. Okay, let's do this. And I'm going to make sure I get it right here. 14 pages of utter what just happened there? It's astonishing. Okay, so here's how it starts out. I'm going to go over here. Introduction, the Southern Poverty Law Center. State admission included the dismantling of white supremacy and confronting hate across the country. Now, that is a meritorious thing for which the organization has received huzzas for decades now, okay? But when you started to see how they used lawfare to shake down, I mean, nobody's down with the racists, right? Nobody's, I mean, do you know people who hang out with Nazis? Me neither. But this is just a ploy by which the SPLC shook down organizations to bankrupt them. Get it? Bankrupt. So they sort of started that template with respect to political organizations that they detested and wanted wiped off the face of the earth. I remember doing stories in San Diego. There was an organization that I can't remember what it was, but it was definitely a white supremacist organization, sort of a little branch off the KKK tree, and it was named something White Aryan Brothers, was it? I don't remember. Anyway, so I used to call their telephone recording line where they'd give all their latest updates, and man, they were put out of business like none other, very quick order. And that same thing happened in an organization in Portland, Oregon. So it was happening along the West Coast, and so it happened in San Diego, happened in Portland, and happened elsewhere. That who's one of the. It surprised no one who pays attention that an SPLC attorney was arrested in Georgia, Atlanta, Georgia, at an Antifa takeover in the Stop Cop City. So this person was an activist and an attorney and was arrested for breaking the law in Atlanta, Georgia. This is not, this is not something that is an one-off. It is a ubiquitous thing, it sounds like. It is something that occurs quite often. So, according to this amazing, astounding document, the SPLC had a field source who was a member of the online leadership chat group that planned the Unite the Right event in Charlottesville, Virginia. That field source made racist postings under the supervision of the SPLC and helped coordinate transportation to the event for several attendees. There's no number that we have attached to that, but we do know that there were official buses that came, and in buses, according to an eyewitness from whom I hope we can hear later, because this is going we're 20 minutes into the show already. You know what I'm saying? This is, whoa. And I've got Richard Epstein coming on. I'm going to drop everything, go to Richard Epstein on the 14th Amendment stuff, and then I'll come back to this, okay? But I just want you to know this is a slog, baby. It's a slog. The covert nature of the accounts, this is the Unite the Right event, that field source made racist postings under the supervision of the SPLC and helped coordinate transportation to the event for several attendees in order to covertly pay its field sources. The SPLC opened bank accounts connected to a series of fictitious entities. The covert nature of the accounts allowed the SPLC to disguise the true nature, source, ownership, and control of the fraudulently obtained donated money the SPLC paid the field sources in order to keep the scam going. The SPLC made a series of false statements related to the operation of the account. You can't lie to your bank. You know what I'm saying? You cannot do that. That is inappropriate. And the know your customer thing, the Big Brother thing that the left put on the banks following, was it COVID? And they used that to go after, they debanked Donald Trump. They said, well, we don't like you. We didn't know you were a secret racist. No, really. Just ridiculous. At all times relevant to this indictment, the Southern Poverty Law Center was the nonprofit 501c3. So we're just talking about the C3 right now, okay? According to its website, the SPLC is a catalyst for racial justice in the South and beyond, working in partnership with communities to dismantle white supremacy, strengthen intersectional movements. That's a new ad for recent times, to just give them a little spiff of woke. And advance human rights of all people, except conservatives. So, now to carry out the mission, the SPLC relied in part on public and corporate donations. They talk about the kinds of donations that they get. They receive no government funding, according to what they say. The SPLC website also explained to potential donors your support powers our work to confront hate, stand up to injustice, and defend our civil and human rights. From the courtroom to the classroom to communities across the country, you can help create a more just and inclusive future for all. Huzzah! What they didn't tell their donors was that they were paying these people to stir up trouble or do whatever it was to create the need for the SPLC to come in and get rid of them. But all we need is your money. Now, it's the arsonist who sets the fire, who says, he calls the fire department. This happened in Pacific Palisades. Calls the fire department, and then when the fire department shows up, offers to help put out the fire. You know what I mean? Let's see. These donations were used in part to fund various publications. Here, I'm right here. Including the Intelligence Report and the Hate Watch and Intelligence Project Dispatch, a work product that they sent to their donors. Look at us. You're using your money really well. Yeah, okay. The Intelligence Report was a magazine-like periodical published by the staff of the Southern Poverty Law Center Intelligence Project, provided free of charge to law enforcement officials, journalists, scholars, and others, and they took that information and they ran with it. Well, Charlie Kirk's on the Hate Watch. Laura Ingram's on the Hate Watch. Other people had the targets put on their faces by the Hate Watch people at the Southern Poverty Law Center, because they're people of either faith or they have conservative values. And, these people, these lefties over here just can't have that. Worse, however, is the fact that the FBI during the Biden administration, the journalistic community writ large, they took it and ran with it. Well, come on, the SPLC, let's believe it, boy. Now, here's the thing. The folks over at the Bulwark, which is an organization, Bill Kristol's place, and he hates Donald Trump. Okay, he doesn't like him. He's not a doctrinaire Republican, so therefore Donald Trump must go. And he's not a, what do they call them, neocons, which is what we talk about with respect to Jews, because everything's the Jewish problem, even though Bill Kristol's a Jew himself. Well, anyway, so Bill Kristol's people right over at the Bulwark, many of whom I appreciate. I mean, these are very smart people. I will give them that. But one of the things they bring up, which I think is a good point, is that we need more specifics in this indictment. And to that, Mike Davis over at the Article 3 Project says, wait for it. This is an ongoing investigation. Why would he know? He knows all these guys. And in addition to that, there will be a superseding indictment. So don't you worry now. Don't you worry. So the Hate Watch was a blog operated by the SPLC that monitors and exposes activities of the hard right of the United States. And by providing SPLC with an email address, a person could receive the latest updates from Hate Watch. The Intelligence Project Dispatch was the monthly online publication by the Hate Watch staff, and it monitors and exposes white supremacy and its impact on communities. I think we can all agree that racism is bad. That's bad. But that's not what they were doing. They were going to these specific groups and going, hey, psst, come over here. We're going to pay you out. We're going to have you do a few things, and we're going to report on it. And we're going to use you as one of our poster bad boys. And we're going to tell all our donors about it. And you got to be okay with that as long as you take the 70 G's. Okay, dude? Yeah. Oh, okay. The top banner of the SPLC website had a link for public donations. By clicking the donate button, potential donors were brought to a web page that explained how to donate money to the SPLC. This page also informed donors with your support, the SPLC Action Fund will pursue a bold action agenda to confront our country's most urgent challenges. Together, we'll uplift progressive candidates who uphold inclusive democratic values while investigating and exposing candidates using hate and extremism to gain power. If that is an election law violation, by the way, it's a 501c3. This is what their 501c3 website talks about. You don't say that you're going to espouse particular candidates and or a particular political party of which they speak. The Democrat Party here, the leftist values, the woke values, and not have the election FEC come in and go, yeah, I don't think so. You guys, you can do that in a C4. You could educate in a C4, which is how a lot of these groups get away with that stuff. But that ain't that. That's a C3 stuff. So anyway, they paid informants. So the paid informants, the Fs, these are the, which they called, let's see, what did they call them? The field sources. These informants were referred to by some individual within the SPLC's field sources, or the Fs, the field sources. So between 2014, I beg your pardon, I said 2015, I beg your pardon, it's between 2014 and 2023, the SPLC paid their field sources in a clandestine manner. Doing so hid the fact that while the SPLC received donation money under the auspices that the funds would be used to dismantle violent extremist groups, this donation money was instead being used in part by the SPLC to pay leaders and others within these same violent extremist groups. That money was then used for the benefit of individuals as well as violent extremist groups. Yeah. They have several, examples. A, F37 was a member of the online leadership chat group that planned the 2017 Unite the Right event in Charlottesville, Virginia, and attended the event at the direction of the SPLC. The F-37 made racist postings under the supervision of the SPLC and helped coordinate transportation to the event for several attendees. Between 2015 and 2023, the SPLC secretly paid F-37 more than $270,000. So right at the moment where Trump is ascending, he's in ascendance. Hillary, we got to get rid of white men. I guess that was part of the reason. It had to have been, I believe, a political thing against Trump. That's when they ramped this stuff up. And then, of course, we resulted in the 2017 Antifa riot with people ostensibly, who were on the right. Well, the guy is getting paid 270 G's to get people to this deal. Let me pause here from this. Let me pause here from this at the moment, and let's go to this conversation. Now, I think this is a legit conversation. This is something I saw on the Twitters, which is X, and this referred to a 2017 conversation that this particular podcaster had with a woman who was a good friend of his. He believed her. They know each other. He trusted her, and he doesn't podcast much anymore, but this was her conversation. She's in a diner in Charlottesville, and she sees the buses. In fact, everyone in the restaurant sees the buses come, and there are people getting out of it dressed like what we know Antifa to look like, and then also people with KKK shirts on and others. This is the same kind of thing that they did at January 6th too. I mean, that kind of thing occurred. You may not want to receive that from me. Just know it is true, but because we have video of that. Okay, we do have video of that. This woman, here she is talking contemporaneously with this guy, just days after this happens. Listen.
Like for all of us to look out, pointed at the buses. I could see 6 of them, but I don't know because the building cut off part of the road, which was across, not really a street because it's a pedestrian-only area, but it was on the other side of that, on the opposite side.
What color were these buses?
Or the lane. I'm sorry?
What color were these buses?
They were like a dark charcoal gray. I didn't notice any writing, but, there were some trees and people and stuff in between us and the buses, so I didn't see any names.
Were the buses the same?
I know they were all the same.
They were all the same buses. And
Yes.
I remember earlier you told me they were back to back. They were like bumper to bumper.
Yeah, bumper
Correct?
to bumper. Like when school buses all follow each other to an out-of-town football game. They followed each other. One changed lanes, the other changed. Well, I didn't see them change lanes.
But I understand what you're saying. They were back.
Bumper to bumper.
They were together.
Yes.
Okay. All right.
Yeah, so they pull up, and of course, my first thought is it's a tour, because I'd been finding out about the history of the town, and it's a pretty interesting town. There's some rich culture here. Maybe there's just, I don't know, a tour going on, like old people go to Vegas together,
Well, since it's a tourist town, so when you seen the buses, you figured it was just like a tourist bus.
Well, yeah, that's what I thought, like a charter bus,
Charter bus. They were charter buses. They were like charter type buses,
well, the
correct?
University of Virginia is here too, so
okay.
It could have been for anything.
Okay, I get it.
So everybody in the restaurant, you could hear cricket. Everybody's just looking, so you could tell that the locals weren't used to seeing something like that. And, within, I want to say, 10, 15 seconds.
Yeah. What? Take your time, I understand.
People came running off the bus and just flooded the place. I don't care what anybody says, and I don't care if anybody believes me, but these people came off that bus ready to, I don't know what, to fight. They had on helmets, they had on knee pads and elbow pads and face guards and mouthpieces and purses and bags and backpacks full of things carrying.
Well, let me ask you this. Hold on. Now, were these all white people getting off the bus?
No. There were just as many black people as there were white people.
So white and black people got off the bus.
Women as there was men.
So white people, black people, men and women got off the bus is what you're telling me, right?
Got off the same bus. I even saw some people carrying, you know, those shields that policemen use for riots that you see on videos and stuff.
The hell they get that
there were
from?
people carrying those off the bus.
Really? No.
Yes.
These black and white people that get off the bus, are these the ones that had on T-shirts?
There was T-shirts, there was emblems, there was. Now I don't recognize all the different groups that are out there.
Right.
The ones that I know of are BLM,
Black Lives Matter.
KKK.
Yeah.
Black Lives Matter, the KKK.
Now you've seen these emblems, is what you're saying.
Yeah, I did. And not just one or two. Everybody on those buses that came off those buses had something on them that caught my attention. Oh my God, that's the KKK. Oh my God, that's a BLM. But
So you're telling me, wait a minute, you're telling me that Black Lives Matter and the KKK got off the same damn bus?
Yeah, but wait a minute. I think I might have left something out. The week leading up to it, those people that I'm talking about that were having those civilized conversations in the restaurant and in the town, they were also BLM. I didn't see any KKK or anything like that.
Okay, so we can stop. So this is a 40-minute conversation, so I'll have to post that. And so you can see it for yourself. You can decide whether or not you believe this lady, if you think she's nuts or something like that. But be reminded, 2017 is when this conversation occurred, contemporaneous with what was going on following Charlottesville, the riot there, and the riot for which the SPLC paid for transportation for some of these actors. Was it those buses? I don't know. How many buses could you buy over a period of time for $270,000? Okay, so let's go back to our indictment issued. They hand them up, that's how they do it. Okay, so now we go to another person, the person that they've got, the field source. F9 was affiliated with a neo-Nazi organization, the National Alliance, and served as an F field source for the SPLC for more than 20 years. F9's activities included fundraising for the National Alliance. I mean, if you're fighting this white supremacist organization, I had to look it up. I didn't, they all have the white front, or, they all sort of sound alike, frankly, which I suppose is part of the selling point for these people, I guess. However, you're paying them. He's writing at your behest all these racist things, and you're still paying him. Between 2014 and 2023, the SPLC secretly paid F9 more than $1 million to keep on doing what he's doing, because they're making it back in spades. I'm telling you, the return on investment for this kind of stuff apparently pays quite handsomely. In fact, they should sell shares. 2014, F9 entered the headquarters of a violent extremist group and stole 25 boxes of their documents. Interesting. F9 coordinated payment for the copying of the materials with a high-level SPLC employee who had knowledge the documents had been stolen. The original stolen materials were returned to the violent extremist group in a second illegal entry by F9. Thereafter, the high-level SPLC employee, utilizing the documents in part as the basis for a story published on the SPLC's Hate Watch website and authored by the employee, another F39, was blamed for the theft and was paid approximately $6,000 to falsely take responsibility for the theft. That was paid by the SPLC. Okay, here's another one. F Unknown was the imperial wizard of the United Clans of America. In an article published November 22nd, 2013, the SPLC described the group as a millennial reboot. They said it was a pathetic millennial reboot of what was once a serious domestic threat. The word pathetic was left out of the indictment, for which the bulwark gave the DOJ much grief. You should have said that. They referred to it as a pathetic attempt. Okay. Okay. Now we've said it. It was supposed to be pathetic attempt because you want to make sure you get all the descriptive words on it. F-27 was reported as an officer of the National Socialist Movement and the Aryan Nations affiliated Sadistic Souls Motorcycle Club. Between 2014 and 2020, the SPLC secretly paid F-27 more than $300,000. That is more than just walking around money, my friends. Here's another guy. F-42 was the former chairman of the National Alliance. The SPLC website contained an extremist file webpage about their own client, their own guy that they sent into the field, their field source. Oh, look, we're fighting back against this guy. Dude, they're paying him. Okay, they're paying him. Okay, this is nuts. Seriously, nuts. Let's see what else. F-30 is the National Socialist Party of America. He's the leader. That's the Nazis, and SPLC was paying him. From 2014 and between 2014 and 2016, the SPLC secretly paid F-30 more than $70,000. The overlap time period in which F-30 was featured on the SPLC's extremist file webpage. So they paid the dude to be featured on their website and to do whatever activities that he was doing. Here's another one. F-43 was the reported national president of American Front and convicted federal felon for his participation in a cross burning. Between 2016 and 2019, SPLC secretly paid this guy, Mr. Crossburner, F-43, more than $19,000. Here's another one. The F Unknown was a member of the Ku Klux Klan and married to an exalted cyclops of the Ku Klux Klan. F Unknown and their spouse were involved in litigation whereby the Ku Klux Klan applied to take part in the Adopt a Highway program. I think I remember this lawsuit. During the course of the litigation, known payments were traced from SPLC to F Unknown, which exceeded $3,500. So that's enough for a filing fee anyway. They're paying them to start stirring it up. Hey, we want to have we want this Adopt a Highway program. We're going to go to court. Do we see the problem here? Are you getting the idea here? I mean, this is like those, remember those kids, the college, all the college websites. I used to read them more widespread than I do now rather. But what's interesting is, when you find that somebody's been attacked and or somebody left a terrible noose or something like that on their locker or on their dorm window or something like that, invariably in the vast majority of these cases, these woke college students at the colleges, we consider them to, wow, these guys must they're real racist. So no, it's the people themselves who say that they are the victim of a racist incident and make it up to bring more attention to themselves. That invariably, that's what happened. That's what they're doing here. And then they try to get a settlement out of you. Okay, the SPLC had fictitious entities. They secretly funneled donation money to their Fs, their field sources, including a person who would become the chief financial officer and a person who would become the director of intelligence project, Employee 2. Among others, opened a series of bank accounts at Bank 1 and Bank 2 in the name of various fictitious entities, including but not limited to the following: the Center Investigative Agency, otherwise known as the CIA, Fox Photography, Northwest Technologies, Tech Writers Group, Rare Books Warehouse. These were never incorporated. There were no bona fide employees, and they conducted no actual business, but they did serve the purpose of being able to be used to lie to the banks about them and buy stuff online, wire transfers for which they've been indicted, and the know your customer laws, breaking those. I mean, this is fraud, right? This is fraud. So anyway, counts 1 through 6 are wire fraud. They talk about all of these things. These are the times that a wire transfer or transaction in the amount of approximately $47.50 from the SPLC operating account at Bank One to a First Citizens Bank account controlled by F9. That happened. So they go through all the occurrences of the wire transfer fraud. Count 7 through 10, false statements to a federally insured bank. Oh, no, you can't do that, right? Lying to the bank. There's only one entity that hates being lied to more than the government, and that's banks. Don't you mess with them. They don't like any of the competition. But here's SPLC, count 7 through 10, false statements to a federally insured bank. And that's what happened as described in paragraphs 14 and 15. Individuals, the SPLC, open bank accounts were CIA, Fox Photography, Northwest Tech, et cetera, et cetera. The purpose of opening these bank accounts for the fictitious entities was to be able to conduct financial transactions that made it appear, I got a hair here. Sorry, beg pardon. Receiving fictitious entities rather than receiving donated funds from SPLC. They wanted to hide where the money was coming from. And they give all the examples of that happening here. See this, 10 incidents. Now, then finally, the coup de grace is count 11. Count 11 is conspiracy. And you may think that, 2015, 2014, 2013, it's 2026. There's a 5-year or 10-year statute of limitations on these things. You can't do that. This is dead on arrival in the federal courts. No, wrong-o. When you allege conspiracy, the active date of the conspiracy is the last date they used the conspiracy. They engaged in the conspiracy. Now, we don't have the names of these people, and we should have the names in the superseding indictment, which I assume will happen. And we've been told will happen. Mike Davis has said as much. Okay, so now they want forfeiture. Allegations. They're giving the SPLC a taste of their own medicine here. This is what the feds are asking for. Let me make sure. Manner and means of conspiracy. They talk about that. Let's just get one little taste here. Manner and means of conspiracy. After receiving the donated funds via wire fraud scheme alleged in counts 1 through 6, individuals at the SPLC transferred proceeds of the wire fraud scheme from SPLC's operating account at Bank One to another account in the name of the CIA. So this is how they did it. This is what they allege. And then they allege the allegations contained in counts 1 through 6 are hereby re-alleged and incorporated by reference for the purpose of alleging forfeitures pursuant to Title 18 U.S. Code Section 981, blah, 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 Title 28. Upon conviction of these offenses, they're demanding that Southern Poverty Law Center forfeit to the United States any property, real or personal. Imagine they're going to get personal property. They're going to have to get names in here, I think, which represents or is traceable to the gross receipts obtained directly or indirectly from the offenses in violation Title 18. If any of the property described in this forfeiture allegation as a result of any act or omission by the defendant cannot be located, has been transferred or sold, has been placed beyond the jurisdiction of the court, which we understand lots of activity has been occurring overseas at bank accounts operated and controlled by SPLC. This is wild. So now we go into the forfeiture. And as I said before, this is giving the SPLC a taste of their own medicine. They bankrupt everybody. That's what they try to do. They can't get them on the merits because you can be a racist in the United States of America. You can't hurt somebody and you can't commit an offense which is against the law. But you are somebody, you can have the stupidity in your own mind that you are, you're a racist. You can do that. I mean, we don't advise it, but it's not illegal. not illegal. But if they bankrupt you, then they've got you. They got you by the short hairs, and they're going to get you. Yeah. So, a lot of, I will say that people talk about, MAGA, your cultists. And I have to say, here's one guy. Let's see. MAGA are Trump poorly uneducated. I don't know to what this person's referring, but if you're talking about going through an indictment, a 14-page indictment for the viewers of a program who may consider this to be not much more entertaining than watching paint dry, I think that that's not dumb. That's smart. I think that's smart to do that so people can see what you are talking about. And like I said before, when I see Richard Epstein join the chat, I will be going to him and then I will resume this coming up. But let me tell you something. A heck of a lot of people were hurt by the SPLC over the years. And they were hurt, for example, I know that President Trump is a big boy and everything, but the Charlottesville riot, paid for in part by the Southern Poverty Law Center, was misused and mischaracterized to twist Trump into being some sort of racist. Remember that? And I'm going to play you the entire 5-minute and 38-second soundbite in which the actual context for the fine people on both sides thing went down. But, or maybe I should just do it. But it was used against him. Here's a little snippet. These were from Greg Gutfeld's show. Let's listen.
Charlottesville, where there was a mob of people carrying tiki torches, spewing anti-Semitic hate. And what did
I wonder if SPLC bought those tiki torches for Richard Spencer, the socialist.
the president then at the time say? There were fine people on each side.
Who said that there were very fine people on both sides of a white supremacist rally.
David Duke and neo-Nazis, apparently for some, don't meet the Republican villain test. Oh, that's right. I forgot. There are fine people on both sides.
6 years ago, neo-Nazis marched out of a field in Charlottesville, Virginia, literally carrying torches.
Paid for. This riot brought to you by the Southern Poverty Law Center.
Neo-Nazi flags. What'd you hear? There are very fine people on both sides. President Trump had said, what do you think? He said, there are very fine people on both sides. He said there were, quote, very fine people on both sides.
Okay, this goes on and on and on. Multiple times. Remember when Joe Biden gave the red speech? This is fun. He gives the red speech, and remember that Philadelphia in front of Freedom Hall, and it's just like the two Marines on the backside, and he's lit. Joe Biden is with red light. He looked like a maniac. Okay, and he sounded like one too, actually. And he talked about this white supremacist. This is the worst thing in the world. You know, I'm not. I don't think white supremacism or any other racism is a good thing. I think people need to get along together. But they don't want people to get along together. And SPLC was paying people not to get along together. They were being divisive on purpose. They needed this divisiveness. They needed this divisiveness to sell themselves to donors and to also sell what they have to the media to continue to form a narrative which was bought at hook, line, and sinker by the mainstream media.
Yeah, they ate it up for years. Every hate map was treated like gospel. If they said your neighbor's bowling league was a hate group, boom, front page, no questions asked. Meanwhile, the actual number of active hate groups in America has been about as robust as Blockbuster Video.
And he goes on. So we'll pick up the thread on that coming up. But this is extraordinary. And whether or not you think the indictment is a little treacly, maybe it's not as robust as you'd like to see it, or you think it's not good enough. You think that the Southern Poverty Law Center has been besmirched by this thing. Well, fine, you can have that opinion, but just know this. There's going to be a superseding indictment, and woe betide those people who've been carrying the water for this organization, which used to be a meritorious organization. I can remember it. And within my lifetime, I admired them. But then again, I used to admire the ACLU, and I don't have much respect for them these days anyway. But they picked a side, and now it's not my side. And so I thought civil liberties was, something we'd all be in favor of. But it turns out not so much. Most Americans, I'm going to switch gears here. We're going to talk about the 14th Amendment. And actually, I'm going to listen, and I'm going to let my guest speak because he's the expert here. But most Americans can't get past the completely, really dumb idea that there's something wrong with now imprisoned cartel kingpin El Chapo sending his wife to L.A. to give birth to American citizens. He did that multiple times before he got put in the slammer in the Supermax. And they can't get past the idea that the country isn't made greater by pregnant baby mama machines run by Chinese billionaires to create American citizens, and how they're being sent to American territories to give birth, and to create an American citizen. People see that and they go, why do we allow this? This is insanity. I thought we said that the Constitution wasn't a suicide pact. Well, it turns out it's been a suicide pact to some people's mind. And moreover, we're told now, they're told, but they don't really know, I'm included here, if the 14th Amendment that granted citizenship to African slaves and made sure that their children were considered to be citizens on American soil, grants those same rights to people who just broke into the country illegally and they haven't even filled out an employment form yet to get a job. They're just hanging around. Now, who's right? Do we do this? Is this what our Constitution is supposed to do, this 14th Amendment? Does it really read that anybody, anytime, anywhere could come to this country, have a baby, and then give birth to an American citizen? And after 4 years of Joe Biden opening the border, that question, he let in 20 million people, it is estimated by some. I've heard that more than many times. Can all of those people just have kids and just become American citizens? Does that make sense to you? No vetting? Well, on day one of his administration, Trump 47, Donald Trump issued Executive Order 14160, titled the Protecting the Meaning and Value of American Citizenship. And he signed it the first day he was in office. And, it's immediately seized upon by the ACLU. They got an injunction from a very willing federal court judge and district judge, and it became a national injunction. Rinse, repeat. And in it, President Trump said, or whoever wrote this for him, he says, not everyone's conferred American citizenship. That shouldn't be for illegal aliens, etc. The ACLU found a way to stop it, and so it has been held in abeyance until it was taken in by the U.S. Supreme Court in a shadow docket, the New York Times shadow docket. And on April 1st, it was argued before the U.S. Supreme Court in a case that is known by Trump v. Barbara. Very odd name. And what does the 14th Amendment really say, though? Does it say what the ACLU claims it does say? One of America's brightest constitutional scholars says, not so fast. Nope. Richard Epstein is the Laurence A. Tisch Professor at NYU, Senior Fellow at the Civitas Institute at the University of Texas, Austin. He's a senior lecturer and a professor emeritus at the University of Chicago. He's forgotten more things about the Constitution than people have in their heads and are considered experts. He is the author of many books, and his latest book is called The Myth of Birthright Citizenship. In it, he explains what the Constitution actually says about this. And I am so thrilled to welcome Richard Epstein to the Adult in the Room podcast. How are you, sir? I can't hear you. Oh, no. Oh, no, we have a, okay, hold on. Here we go. I think I'm unmute mic. I think you got your mic muted.
Do I have it muted now? I don't think so.
You are good to go now. I can hear you, sir. How are you?
Well, I want to make sure that when I look on this screen, you don't only see the fact of the top of my head. So let me move the
Now, just
screen
move
over
your screen down a little bit so I can
and
get a.
see
Well,
if I
hello
can
there.
be much more handsome than would otherwise be the case.
No doubt. You know what? You are a lot younger than I always imagined you to be. I've listened to you for years. I love law talk.
I'm 83.
Are you really? Wow, you look
Well,
great.
well, thank you. I mean, sparring with the angels and the devils sort of keeps you young. Yes, I've been teaching since 1968, so I think at
Jeez.
this particular point in time, I may be one of the 2 or 3 most senior law professors in the country who's still active. And my view about all of this is very simple. If you don't stop moving, you keep on going. If you do stop moving, you can never start again. So I wrote this book, which you referred to, mainly because of my peculiar background. I was an English trained lawyer who studied Roman law in Blackstone in my youth. And one of the things that happens when you study these things, you have a very different sensibilities to the origin and the way in which various legal doctrines work. And it has to be remembered that the people who drafted the Constitution were influenced, both for better and for worse, by what happened under these various systems. And so when I first saw the birthright citizenship stuff, I said, this can't be right. And I said, why not? And I gave a maxim to prove my point, which was no rights can arise out of wrongful conduct. And this is a basic nonsense. And usually you do the wrongful conduct for your own benefit. And there's a whole series of legal doctrines which talk about the principled extensions. And one of them is if you do it in order to benefit your offspring, that also counts as an illegal doctrine. You can't do it. So the moment I first heard about this thing, I'm saying nobody could profit from their own wrong. And it turns out the usual rules when you come into a country, you come in as a guest, you don't come in as a citizen or potential citizen. And as I later discovered, Blackstone covered this case very well by calling it a case of local allegiance, meaning only so long as you're there do you have to obey the traffic rules and everything else. But once you're gone, you're gone. And at no point can you confer citizenship upon your children or yourself, because the basic rule on citizen was that you own the sovereign a degree of loyalty. It owes you a degree of protection. And that is not the general situation with respect to visitors. They have to follow the local law. But as Blackstone says, once they're gone, they're no longer a part of the situation, and their children can be no better than they can. I then started to say, well, is there anything else about this that you need to know? And of course, it turns out there is. And so the first thing you do is you read the Constitution, and it says any person born and naturalized in the United States and subject to the jurisdiction thereof. You notice the word naturalized is built into the text. And what does that mean? Well, it's amazing as it sounds. If you listen to the oral argument in the Supreme Court, nobody bothered to mention what the Naturalization Acts were. And so I decided just to take a peek at them to figure out what was going on, because in the first Congress, virtually every topic was a subject of a statute. We have courts, we get a Judiciary Act, we have a Post Office, we get a Post Office Act, we have copyrights and so on. And I read this thing and my eyes absolutely blew apart. The first sentence in the Naturalization Act of 1790 was every free white person is eligible to becoming a citizen. That is, we built a race bar into this particular statute. And one of the things that's so clear is that bar remained in effect all the time through 1870, when for African Americans or persons of African descent it was lifted. It was not lifted for Chinese persons until much later, in the late 19th, early 20th century by degrees. As I said, wait, now if you know this, it turns out, well, in order to be a citizen, if you're not born in the United States, you have to be naturalized. And you read the statute, not only is there that requirement, but there are lots of other things that they worried about. You had to be of good character. And one of the critical rules that you mentioned, of course, is that the only way a minor child can be naturalized is if its parents are naturalized. And this was a rule everywhere throughout the world. And if you listen to the Supreme Court argument, you had this bizarre discussion by Amy Barrett about how you determine the mental state of a 2-year-old child or a newborn child with respect to permanent residency. And she only did that because the statute itself didn't talk about domicile, but the case called Wam Kim Ark from 1898 did. And she was trying to treat that as the original text, even though there was a statute out there which said very different things. And so if you looked at the particular case, one of the things it said is that this was a Chinese person. Well, Chinese persons were not eligible for naturalization. And then the second thing it said is you had to show renounce all loyalties to all other sovereigns. And if you're traveling on a Chinese passport, you're not doing that. So if you read the first two sentences of the case, it's pretty clear which way it comes out. And then he manages to twist and turn and to make it go the other way. And that's why you have the kind of incredulity you showed at the beginning of the show. This doesn't make any sense at all. Well, it didn't make any sense to anybody when it was done. So I wrote a brief with my former student, Ben Flowers, genius kind of a guy, in which we try to point all this out to the Supreme Court and say it's utterly inconsistent with automatic citizenship in the classes you talked about. What was so astonishing about the Supreme Court case, nobody even talked about the naturalization statutes. They just ignored the whole thing. And they spent their time talking about words that they didn't understand and making factual claims that in general were wrong. And so it was really a kind of out-of-the-world experience. Here is a clear situation. There is a series of provisions which you have to satisfy to become a citizen. And as you mentioned, birthright citizenship is claimed by people to be automatic without having to go any of these requirements. Well, that's a clear circumvention of what the appropriate rules are. And therefore, what happens is when they passed the 14th Amendment, these prohibitions in naturalization were still in place. The prohibition against persons of black descent becoming citizens was only lifted in 1870. And so the argument is in 1870, we allowed people to apply for citizenship if they meet all the other requirements. But in 1866 or 1868, we had already let them in unconditionally. It is just bizarre. Well, to justify, I don't. Do you want me to go on? Or ask
Yes, please. Yes, because we came to hear you. So
okay. Well, I like hearing you too. So what happens is the question is, what about the the Constitution? It says, persons born in the United States and subject to the jurisdiction thereof. And the ACLU began its brief with an outright falsehood. And what that falsehood was is that anybody born within the physical territory of the United States was subject to its jurisdiction. So all these people get in, and you then have to figure out why is it they escape all the requirements of the Naturalization Act. And there's really no good answer to that, because if you went back to all the other situations, in opposition to this local jurisdiction while you're a tourist, which was fully recognized in the American laws in a case called the Schooner McFadden in 1812, the general requirement was the same as in England. You had to meet the standard of naturalization as set out in the statute. So Justice Kagan sits there and she writes as though there's a common law of naturalization. There's no such thing. And under the American law, the naturalization clause had first the statute in 1790, then 1795, then 1802. This was a big topic for which it was done with a lot of controversy. And to say that people just waltzed into this country and had birthright citizenship as a matter of common law right shows no understanding about the way in which this particular system was worked. And this was a really tough kind of issue. Well, as we start to go forward, you then have all the Chinese cases, and the Chief Justice makes a corker. What he does in response to the government lawyer, Mr. Sauer, he says, everybody knows it's the same old Constitution, but the facts are different. Too bad for the facts. Well, he got everything wrong. It turns out it wasn't the same Constitution. What we did in 1885 is we passed a statute called the Chinese Exclusion Act, in which you have some pretty foul things saying about the worthless nature of Chinese individuals who will destroy America. And then an American Chinese person named Ping wants to come back to the United States where he had left with a passport and the permission to do so. And if the federal government only had the naturalization power, it couldn't keep him out, right? Because the only thing that naturalization does is convert somebody into citizenship. It doesn't deal with exclusion. And there's a peculiar gap in the Constitution because there's no state court that is in control of the District of Columbia. So the whole statute was a little bit whacked up. And so what Justice Field says for everybody is, wait a second, it is an inherent power of the natural government to control immigration, full stop. And that essentially transferred all the power from the states to the national government. And this was not trivial. Every state had extensive control over immigration. And now all of a sudden, the whole thing goes to the federal government. And nobody raises a peep about this. By 1891, there's a huge statute that regulates immigration. And by 1941, during the Second World War, it was decided by the Supreme Court on the basis of no evidence, but the right decision nonetheless. What it decided is not only is there federal jurisdiction over immigration, but it tops that of the states. So what we did is we had a constitutional revolution that put everything upside down. And the states were now not really important players with respect to immigration. And the Chief Justice did not mention that. Then he got everything wrong on the facts. They didn't use airplanes. Well, they didn't use airplanes in 1870, so to that extent he's right. But starting with 1850, when there was the construction in the gold fields in California, there was a fairly massive Chinese immigration coming into the United States. This was not an unregulated immigration. And in fact, in one of the chapters of my book, I go in through all the cases that deal with this subject, and it's something of a real nightmare. We go up and we go down. But the one constant throughout this entire period is people may be able to come here from China, and Americans would have greater privileges in trading in China, but no Chinese person could be naturalized as a citizen of the United States. In fact, the national power over immigration was so strong that we could bounce anybody out and keep anybody out if we didn't want them in there. We didn't have to give an explanation. And who was the guy who wrote that case? It was Horace Gray, same guy who 5 years later wrote Wong Kim Ark. So on the one hand, he's saying we could bounce everybody out. On the other hand, he's saying some of these people were citizens. And it really doesn't make any sense. So what had to happen in this case is the Chief Justice sort of said, look, this was a problem over 150 years ago, and we solved it by having these strong restrictions. And so the problem is the same today, and the constitutional text is even stronger against people coming in. And so there's no way in which you could say that the Constitution or the facts justify birthright citizenship. And I mean, I could not understand how we could not even mention these things. Now, I know why the government argued the case it did.
Yeah, well, I think they were cribbing notes from your book, is what I was thinking. It was
no, I wish they had. They did exactly the opposite.
Oh no, I heard John Sauer say a couple of things that I've heard you say.
Only a couple of things, but let me tell you what he didn't. He didn't talk about the Immigration Acts, rather the Naturalization Acts at all. And so he did talk about subject to the jurisdiction. He did a pretty good job on that. But when they started to ask him about Wong Kim Ark and all the silliness about how you determine the nationality of somebody who's domiciled in the state, he never went back to the original text under the Naturalization Act. He just let that slide. And so what happened, he got peppered on an issue that he should have never had to talk about. And his decision was clever, but wrong. What he said is, look, I don't want to get into trouble. Wong Kim Ark is treated as sacred text by many people, particularly on the left. And it was the centerpiece of all the arguments that were raised by the ACLU and everybody on that brief. He says, I want to win by using that case, not by finding him. Wong Kim Ark was a permanent person. These other guys are temporary, as you mentioned. Yeah. Wong Kim Ark was legal, right? And these other people were illegal. So we could accept Wong Kim Ark and still win. Now, what's wrong with that argument? Well, it turns out I could tell you what happened. What happens is there's a passage in the opinion which is worried about the following very important question. In the first half of the 19th century, lots of people came over. They were supposed to be naturalized, and they never did. And they have children, they live in this country. And he's frightened to death that all these people are going to be expelled because they didn't go through a ceremony that they could pass. And he says, that's what I'm worried about. And he was right to do it. Now, there is an answer to that, which only a Roman lawyer will know, and it's the word involving use of caption, gaining something by use. And in the classic system, if you stayed for a long enough time and you were entitled to be there, they would waive the formalities, like in a common law marriage. The problem is, if you go back to the Roman text, you cannot use of caption when there's a legal prohibition against your gaining title. And that's exactly the situation with the Chinese. So they don't get the benefit of a doctrine when there's an explicit law which keeps them out. But all the Scots and Germans to which the justice referred, that is Justice Gregg, they would get the benefit of that doctrine because long use is a substitute for title. This is called a doctrine called prescription. And you'll say, oh, it sounds kind of exotic. If you've heard about it, I'll pat your forehead, but I'll bet you have never heard about this stuff. No. Well, there's no reason why a normal person shouldn't have to hear about that. But we're lawyers, right? And so you go back and you read all the text. And the most important writer in the 19th century was a Swiss man named Vattel, who wrote a book on the law of nations. And he has pages and pages talking about the question, do we have a right of prescription? Answer yes. How does it operate? And he explains why we have it. And so one of the great issues about how the law works is if we give people a prescribed path by which they could do something, they walk down the path, but they don't meet the formalities. Do we waive the formalities after the passage of a long time? And the answer to that question was yes. And that's the way in which Justice Gray should have written the opinion. These people are all protected because there was no prohibition. Mr. Wong Kim Ark is not protected because there was a total prohibition in place, and he cannot overcome that prohibition by staying there for a certain period of time. They didn't do that. And so now what happens is you look at that passage, and Mr. Sauer has said, look, the dicta is broader than the holding. Mm-hmm. And he has answers to this because there's one of the lower court judges named Bortman who tried to deal with this issue, and she made a mess of it. Now, why is that? Because you asked two questions. How many times in the world do you ever have a situation where somebody who enters a country or a place illegally has the same rights as somebody who entered it legally? So take a private law entry. You own a house and you invite somebody into the house, right? And if you don't care for the place and you injure them, you could be held liable. Now a trespasser breaks in. Do you owe the same duties to the trespasser as you owe to invited guests? And the answer in case is of course not. And so what Sauer tried to say without luck is that, look, you accept Wong Kim Ark and all these exotic people come in and there's no real crisis, but you don't extend it to people who are trespassers any more than you do it with ordinary homes. And she got the question completely wrong. And then she said, oh, by the way, everybody knows in the jurisdiction means the same thing as subject to the jurisdiction, when every close reading of this thing indicates that these terms were used not as synonyms, but as opposites. So we use the term within the jurisdiction in connection with the Equal Protection Clause. Now, the Equal Protection Clause today is covering everything under the sun, but that was not true when the Constitution was there. You have to look at the way the 14th Amendment was constructed. And there's a Privileges and Immunities Clause, and that goes to the newly found citizens. And then there is a Due Process and Equal Protection Clause, which deals with all persons, including aliens. Well, clearly, they got to figure out some reason why you differentiate between the two of them, right? And it clearly is relevant because they had just defined what a citizen was. Now they tell you what the payoff is for being a citizen. And what they really wanted to do was as follows, is they were very worried when they drafted this amendment that you could run a kamikaze criminal trial against an alien without giving him any protection. And what the Equal Protection Clause says, we have a frame of laws within the jurisdiction. And what happens is if they want to punish you, they have to punish you in accordance with the restrictions of that clause. If due process, they said, well, they didn't say within the jurisdiction because due process rights at the time were understood to be completely normalized and understood. You had the right to a hearing before an impartial judge. And that's true of everybody, everywhere, so you didn't have to specify it was within the jurisdiction. Now, privileges and immunities are very different. And it's still true today. So somebody comes in from overseas, knocks on the door and says, I'd like to have a job. Everybody says, you're not a citizen, you got to get a visa, right? Mm-hmm. And you want to buy property, and you're from overseas. They said, nope, you got to get a license to buy property. You could rent, but you can't own. So citizenship has real advantages over being a restriction person. And that's why you draw the distinction. And that gets completely lost everywhere, so that the Equal Protection Clause then gets completely separated from the criminal law, and it becomes an all-purpose vehicle, wholly without regard to the consent. And so, for example, it's been applied by Justice Brennan in voting cases, but there's something cockeyed about that. Aliens don't get the vote. So why is it the Equal Protection Clause gives the same rights to all people? Does it give aliens the right of result? No. So he says sometimes the equal protection clause applies to all citizens in civil cases, and sometimes it applies only to criminal procedures. So he's playing games on the use of the word. It's important to understand that the basic organization of the Constitution in 1868 was not drafted by a bunch of modern progressives from the state of California. Half the people who signed on to this were very conservative and were defenders of segregation. And so the question is, how does that manifest itself? And then how does it go crazy? I think it's an important thing to understand this. Well, it turned out there was a big debate at the time of the 14th Amendment on the question of whether or not blacks could get the vote after being freed. It's not required by the definition of citizenship I gave you. And there was a huge debate, and they decided to withhold the right of votes to black people because they wanted to create a kind of segregation. And so there's then a case in 1874 called Virginia Minor versus Happerstat, in which the United States Supreme Court said, we have this privilege and immunity clause. It doesn't give women the right to vote. It only gives them the right to protection that they had beforehand. And that decision completely held, right? Because women only got the vote through the 19th Amendment 20 years later. Well, basically the same rule was made with respect to blacks. And what makes it really complicated is blacks are protected to some extent by the 15th Amendment about the right to vote, right?
Yeah.
Well, you then start to read the cases at the time, including one called Yarborough, and it was something of a surprise, and maybe not right, but what they said, it only protects the right to vote for black people if there's an independent federal right to which it attaches. But it doesn't attach generally in situations where you just want to claim the vote. And that's exactly the way they had decided it in whatchamacallit in 1874. And so votes were out. Then what they also did, and these guys were both clever and evil. What they said is voting is actually covered by the privilege and immunities clause of the basic Constitution. And what it says is all voting rights are in accordance with the rules in any local place. So there's no federal rule over voting. In fact, that was the original constitutional design. The federal government has no role in the voting cases. And of course, that did not last. And when you try to figure out how it disappeared, they did cite things, they didn't cite things, and all of a sudden it was reversed. This happened in the 1930s and the 1940s when they forgot about the Yarborough case, and slowly things started to turn around. Politically, it's a blessing, but constitutionally, it was very confusing to do things this way. And so it was that. And then there was the other question, what about segregated schools?
Yeah.
What happens is the people who wrote all the leading things, the Supreme Court, and the two leading articles on this, one by a man named Alex Bickle, who died in 1974, and the other by a man who's my student, a great man named Michael McConnell, who wrote about it about 30 years ago. They both argued that the 14th Amendment banned segregated schools. But it turns out they never looked at all of these cases having to do with exclusion and naturalization. And once you look at that, this is what the situation looks like.
Well, how come they don't do it at the Supreme Court level then? What are those clerks doing?
I don't know. I wrote this brief. I mean, it's not as though it's not there, and the book is coming out, and it says all of this. That's why when I sort of looked at this, I couldn't believe myself. It was like watching a show in which nothing took place. I mean, I was stunned at what I found. That is, when I came into this, I had this technical animosity. But then when you start looking at the statutes and everything else, the case builds up. Now, you may want to change this, but understand what's going on.
Yeah.
The new strategy on left and right is called originalism.
Right.
I mean, what do they say at the time of the public meeting? Now, the view of many people, both on the left and the right, if it's original, it's good. But I could spend a long time with you showing you all the mess-ups that they made in the design of the original Constitution, many of which were just overridden by judicial decisions, which, to put it mildly, were dicey. The fact that it's original doesn't mean that it's nice. But in fact, the decision about not allowing anchor babies to come into the country and get citizenship is one of the things that they did correctly on that, right? So let me tell you what the tragedy is, because Now these
Well,
guys
let me just textualists though. Are textualism is that originalism and or because we're all
well, I
textualists
mean,
now,
there's a
according to Lady
learned
Kagan.
difference between the two of them. A textualist only looks at the text, and it turns out originalists can't do that. That is, just to give you simple things, the United States Constitution does not say a word about sovereign immunity, and yet it's a
here we
big
are.
topic as to what the Constitution does or does not apply. The United States doesn't use the word police power in it. And the question is, what are the state justifications for the use of force and so forth? That's a topic which takes book upon book. The words are not in the Constitution. There's a doctrine known as unconstitutional conditions, which says we give you a right and we can't condition it on certain other things. So to give you a simple illustration from the 19th century, you have a right to trade in another state, right?
Yeah.
And if you do that, you can go to a federal court to protect your rights because the state courts may be biased. And so some states say, no, if you want to come in and trade in this state, you have to give up your right to go to federal court. And in the 1860s and 70s, they said, no, no, no. This is a structural protection, and you can't ask people to waive it. And so now what this does is it tells you there's another element of complication. United States government has monopoly powers, right? And normally, if you have monopoly powers, you're subject to some kind of law, antitrust law or regulated industries. And the basic proposition that's been accepted everywhere, you got monopoly power, you have to justify why you're keeping somebody out or imposing a condition on them. You just can't do it at will. If you're a firm in a competitive market and I don't want to hire you and you don't want to work with me, nobody asks the question. But those relationships from the beginning of time have always been changed for monopolies. Now, the federal government's a monopolist, right?
Yeah.
And the state is a monopolist. And so the doctrine of unconstitutional conditions attaches to both of them. So I can't say to you, I'm a governor of Massachusetts, and you want to come and do business in my state, you have to agree, if you're going to get a divorce, you're going to have that divorce in my state. And then every state imposed that condition, and you have to have the divorce in 50 states, right? It can't be right because the limitations on monopoly power are there, and that's not a textual stuff. And we're not even sure whether it's an originalist stuff, but what we do know in every legal system, the existence of a strong monopoly power always requires there be correlative limitations on what that state monopolist can do, just the way a private person who runs a public utility or a common carrier is similarly subject to such duties. Now, you can't get that out of originalism if it means textualism. And the only way you could get it out of it if it means supplemented by other things is to have a strong theory. If you go back and you look at the debates, there's not a word in any of them, what do we do with the exercise of state monopoly power? So go back a little bit again. And there is this great question before the Civil War, which sent Joseph Story into conniptions. He was a brilliant man and he knew he was doomed. So the federal government has the power over commerce. And there's a very heavy Southern dominance in the Senate because of the 3/5 rule. Got them a lot of extra votes for nothing. Right? Well, suppose now the federal government passes a statute. And against all odds, it says nobody can sell goods into another state if they were made by slave labor. What would happen to the country? The slave states would be completely isolated. They'd be forced to change their rules, and there would be World War III. And so what happened, this story writes forever in his commentaries why this is not the case. And it's sheer gibberish, unless you understand the point that in any time you've got monopoly power, there's a non-discrimination or price limitation rule upheld upon you. And then the things become clear. He did not see that relationship. And so he made all sorts of crazy arguments. And the Supreme Court then had to address them later on because the issue came up 100 years later with child labor, not with slave labor. And the question was whether or not the state of North Carolina could have its firms ship goods into interstate commerce if those goods were made in a firm which used kids who are under 14 years of age in the thing. The state only had a 12-hour minimum age law. And the United States Supreme Court got the right decision and said they can't impose that condition, which is what they would have had to done in the other case. Unfortunately, they did not have a systematic understanding of what's going on. So the basic worldview is monopolies are always subject to different regulations than competitive markets, like the antitrust law. And you can't get that out of textualism. And even if you have originalism, you can only get to the right position if you understand what's going on. You can't get there by just blundering. And I actually wrote a whole book on this because I couldn't understand what was going on. And I discovered the only way you figure out what's going on is to write about a book about something you don't know anything about. And that's done 30 odd years ago. I wrote it in 1993. But all of this stuff just shows you how complicated originalism turns out to be as a doctrine. And when you're looking at this stuff and you're trying to figure out what's going on, you can't simply project modern theories back into earlier time. So today, if you ask anybody what's essential to having a democratic society, the first word that comes out of everybody's vote is universal vote in elections, right? That's what you'd say. That's what I would say. That was rejected in 1866 explicitly when they drafted the statute. And so you really have to mind warp to understand the way in which these various doctrines start to work.
And you're saying all of that was ignored in the Supreme Court arguments. And then, but do you trust John Roberts to listen to you, Richard A. Epstein?
Well, I mean, he certainly didn't listen to anything I said beforehand. Look, one of the things that you have to understand about the Supreme Court is that explicit racial classifications are absolutely poisonous to the way in which it thinks. And the Chief Justice is a very strong believer in that position. And he denounced as one of the most unforgivable decisions in the history of the world was Plessy v. Ferguson, which upheld various kinds of segregation. And of course, it's a much more complicated case than that as an originalist matter. I think at that particular time, segregated schools were thought to be something which was not a problem. It wasn't even governed by the Equal Protection Clause. It was just a common understanding that what happens is the distribution of public benefits was not covered by the Constitution. And that's a position which nobody wants to accept today. And I have to explain how it was that the change from the earlier position to the more modern position had started to take place. But one of the things you have to note is the practice was well understood at the time. They debated the 14th Amendment before a segregated House in the Congress, and they had 40 acres and a mule that only went to black individuals and so forth. So they thought that that kind of discretion over everything when it came to the distribution of public benefits was the norm. And that rule only started to change in the 1920s. And what the Chief Justice did not understand in this position is that sometimes for good reasons or for bad reasons, this Constitution gets changed by judicial decision. So let's go back to segregation for 1 second. The original scheme was as follows, and two parts of it got broken. The first part of it was that if you're talking about ordinary private rights to make a contract, a will, something like that, the position of blacks shall be put on the same position as white people. And this then gets adopted in the 1866 Civil Rights Act, and they wanted the 14th Amendment to do it. Within 6 or 7 years, you get the slaughterhouse cases, and what it says is not that at all. It says the only thing that is protected is not your ordinary rights to complicate it, but only the right to go on a public river and to petition the federal government. So the entire structure of the Civil Rights Act was gutted by the court. The next thing, which was even more important, is I mentioned to you what the criminal structure was, right?
Yeah.
No discrimination against black people. And then there was a case called Crookshank. And this was a situation where there was a riot and a massacre. And what happened is the federal government comes in under the Civil Rights Act and says, we got to prosecute these things. And the Supreme Court said, no, this is something that should be handled by the local state government, which were the very guys who had murdered the other people. So that the segregation that came out after the judicial system was much more vicious than the segregation that was planned by the founders. But make no mistake about it, they believed in a nice version of segregation. And compared to what happened, it was a nice version of segregation. So if you start looking at more modern people, what they just do is say the whole segregation enterprise was root and band unconstitutional. That may be what we think today, and it certainly is what I think today, but it was not part of what they thought at that time. Think of it this way. there were a lot of people who actually liked the Dred Scott decision, which said incorrectly that if you're born in the Americas as a black person, you're so inferior, you can't become a citizen under the standard rule, which said if you and your parents are in this state, you can't do it. That's what they wanted to overturn reluctantly. But these are not the same guys who are modern Democrats from California. And so you had a lot of very complicated legislative compromises to get to this segregated position. And it wasn't as though it was furiously opposed by blacks, because it did give them a certain degree of autonomy in the shaping of their own institution, which created some really splendid institutions like Dunbar High School and so forth before integration took place. So the history is much more complicated than one wants to do.
Well, no wonder they don't want to talk about it in the Supreme Court.
Well,
then.
I sit there and I'm doing the research for this book on a hunch, and the more I discover, I gasp, and then I finally figured out what these guys were about. They're not entirely evil, but they certainly don't meet the standards of modern social justice, and I would certainly not want to withdraw anything of their view. I'm what we call a classical liberal, which means in 3 sentences, we like freedom of contract, we like limited governments, and we could tolerate, but not quite sure how much to tolerate, sort of general welfare redistribution. And that rule takes every person for one and only one. And after the Civil War, when you go on the female front, things start to change again. Because the first set of civil rights movements starting in the 1870s were about the status of married women. And could they enter into contracts on their own and stuff like that. And the original stuff was very much opposed to that. And then slowly over the period, things started to change. And there was a famous case called Bradwell. And this was about a woman who had the nerve to want to practice law. And you looked at the Civil Rights Act of 1866. It says every person can enter an ordinary contract. You know what the Supreme Court said? They didn't mean that. What did they mean? They said the segregation at the bar in England and the United States is so entrenched that they never meant to change that, and we're not going to change it. And then one justice, a very bright guy, he comes up and says, and by the way, women aren't fit to practice law anyhow. And you could imagine what that did to modern feminists. Wow. Well, it turned out this did not last. By 1879, the president of the United States, Rutherford Hayes, basically told Miss Bradwell, you are now free to practice before the United States Supreme Court. And so that thing went very quickly. But on the other hand, if you check out what are the major social reforms championed by progressives in the first third of the 20th century, they're all sex-related. Women get the protection of various kinds of labor laws. Women are not going to be allowed to have certain kinds of occupation. So what they did is they held up all statutes which gave women protection, and women start screaming, you're protecting us out of a job. Don't do this to us. So by the time they get to, say, 1950, everything on the progressive side had completely turned over, but it took not long to do it. So again, the history of this stuff is much more complicated in terms of the sentiments than one starts to think about. And what you have to do when you go back to read another period is you never look forward. You have to look backwards and see what were they trying to deal with. And then having done that, you then look forward and say, well, how did this turn out? And as I said, on segregation, it turned out tragically because they took the criminal law out of the federal hands where it was supposed to be, and they didn't give you any federal protection of various kinds of basic contractual rights. None of this has anything to do with birthright citizens. So when you look at segregation, it's not a uniform thing. There are all sorts of variations that start to take place, and yet you have to deal with them. And, I didn't spend an enormous time writing this book. I mean, I tend to be a fast writer in this. But the thing that was so surprising to me is every time somebody gave me another reference to read, because I'm not a full-time legal historian, I thought, oh my God, how do we take this into account? Now, I don't want to say I'm not a legal historian. I took a lot of legal history in the United States when I was at Columbia College. And then I went to Oxford, and I took Roman law and English early legal history and English jurisprudence and so forth. Then I come back to the United States, and for some reason, I got involved in another problem just before I started to write this, which had its roots in the late 19th century, which was the way in which you treated the legal systems that were appropriate to both the Philippines and to Puerto Rico and later Guam as a result of the conquest that American had of these places during the Spanish-American War. And it was the same story. Most people literally were trying hard to misunderstand everything that went on. And why is that? Because the fundamental question is, what is a territorial court? And are they organized the same way that the United States state courts are organized? And the answer is they're not. Well, what are the difference? And they spent, a very long time working on this, and the problem still is very hot right now in 2016, because the American Bar Association and the New York Bar Association announced that the decisions made by one of the greatest legal minds who ever sat on the Supreme Court, William Howard Taft, were all racist. And then when it came that they had to have a practical problem, you know what they did? Oh, either we use a unique solution or this thing's going to blow up. So they suspended their denunciation of a racist law in order to solve a practical problem. So it's the same kind of history that starts to take place. People are much too eager to condemn before they're trying to understand. And I'm pretty alone on this. Now, why do I say that? The bar associations, they're supposed to be independent. The vote in the New York Bar and the American Bar Associations were both wrong and both unanimous. So, I feel like a man pushing a rock up.
Yeah,
But
Sisyphus.
my view about all of this is my job. I'm not a politician, right? I don't run for any public office. As an academic, your first duty is to find out what's right and then simply tell it and take the consequences. It's a very naive view today, but I think the essential feature of scholarship is scholars don't get involved in day-to-day politics because it ruins them.
Yes, I could see the way that would be a possibility to ruin people if they get involved in the day-to-day brinksmanship of politics. But with this book, what you've done is you've rolled in a stink bomb into the U.S. Supreme Court, haven't you?
I hope so. Look, you could tell from all the lower courts that nobody wanted to face this as a serious problem because the way they wrote their opinions, they were manifestos. So Judge Borden says, no American court has ever denied the rights of birthright citizenship, and I'm not going to be the first court to do that. And then there was another judge, and what he said is, this is the most blatant argument I've ever seen in my right, and then promptly got everything wrong. And so what happens is the judges essentially started to grandstand right across the board. And they shouldn't do that. If they have an argument, say it. But my view is the way in which you write an article is the way in which you write a brief, which is you first figure out what are the strongest things that have been said against you. And if you can't answer them, you better pull back your horns and rethink your position. And that's exactly what they're not doing in this case. They're not basically saying, how do I deal with the strongest case against me? So I went and I looked everywhere I could to find the strongest cases on the other side. But they all came down to the same proposition. Within the jurisdiction and subject to the jurisdiction as synonyms when they're not. That's the opening paragraph in the civil ACLU's brief. It's the open paragraph in the New York Times articles. It's the opening paragraph in all the things that appear in the New Yorker. It's even close to the same thing in the Wall Street Journal, who on the editorial page basically supports birthright citizen because they misread one Kim Ark. They're not as crazy as the others, but they're wrong. So yes, throwing the stink bomb is not a particularly elegant way of putting the particular point.
But it's effective.
But I think what you're trying to do in this case is to say, you ran through an entire oral argument in which not a single party was prepared to face the kind of historical truth about what's going on. And you got yourself into some really complete mistakes. Justice Barrett trying to figure out the intention on domicile of a newborn child. Right. Justice Kagan imagining that the English rules carried over at common law to America when they were explicitly relaxed in the statute and so forth. Angie Jackson going in there saying, well, I only want to look at the status of the child, not the parent, when the Naturalization Act say exactly the opposite. That's very troublesome. And so you sit there and people say, well, how did you take the argument? I said, eventually I had to turn it off. It was just too painful.
Yeah. Here's the EO, and what the key part of the EO for the Trump administration is 14th Amendment has never been interpreted to extend citizenship universally to everyone born in the United States. It's always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. There it is again. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States subject to the jurisdiction thereof is a national and a citizen of the United States at birth, generally mirroring the 14th Amendment text. Among the Okay, go ahead. You take it away then.
No, I mean, essentially what they do is they get it right, although they didn't spend quite enough attention on the Naturalization Act, because you understand in the United States, if you raise any issue that involves color or race, there are certain kinds of restrictions that you're not supposed to violate. And I'm sure that's why the government didn't want to go back to the statute. And they thought they could win on that one Kim argument I made. But the problems that it raised was serious enough. And Sauer just wasn't prepared to answer those things. So, I mean, I guess, we've been here for a long time. How do I think the case is going to come out?
Yeah.
Well, Mr. Trump opens his mouth again when he should keep it shut. And he says, I think I'm going to lose. Well, I'm not so sure. The real question.
You're not sure? Awesome.
I'm not sure, because I don't know the extent to which this ex post barrage on them might influence them. And it's not me. Let's give you the one fact that scares people. The percentage of babies from overseas born in the United States with dual citizenship is now 10% of the population.
Wow.
And they're all coming from China and related places, and they're all being sent by their governments.
Yeah.
Well, they raised that argument, and there was a lot of uneasiness about it. But again, they got the legal stuff wrong. So Justice Alito points out quite sensibly, there's a person born in this country who is also a citizen of Iran. What if he has dual loyalties to the Iranian government? He wants to spy for them. Well, he asked the wrong question. You don't have to show actual malice. All you have to show is loyalty to another country, at least when you were talking about this in 1866. And so you don't have to do that. Nobody wants to try to figure out the loyalty question when you're dealing with thousands upon thousands of immigrants into the United States. And so what you do is you try to have some very clear birthright rules. And the one is, we don't have to prove actual disloyalty. We have to prove that there was no renunciation of a former sovereign, which you can do by looking at the paperwork.
Have you heard who's going to write the opinion? Because that obviously would give us some sort of clue. If John Roberts is going to write it, I fear for the future of our country.
I mean, my guess is that he will write it. But Roberts is a man, not of deep principle, but he's always trying to find some fix that puts you in the middle, right?
Right.
And so, he wanted to strike down the Mississippi law, but he didn't want to overrule Roe. This was sort of general knowledge. And so if he writes the opinion, it could well be that he finally gets the message on birthright tourism and simply strikes that down and lets the rest of the stuff, whatever that stuff turns out to be, to go the other way around.
There might be a lot of people happy with that.
I think as a political solution, right, not as a legal one, I think that would have a lot of support in this country, because there's no doubt people have very different attitudes to people who wash up on the shore and have no family, as opposed to rich people who come in here. Trump has known that, because remember, he said the purpose of the 14th Amendment is not to protect billionaires. You recall that he says that all the time. His political instincts are extremely strong as to what is or is not his wrong argument. And I think that if you look at the questions, they were sufficiently nervous about the birthright citizenship part of it that they may split it all into two pieces. And if they do that, it would be a kind of a surprise. And when I wrote the brief with Flowers, we said, look, this is the correct answer. We don't think you're going to follow it because the weight of precedent or whatever it is. But then take the intermediate position on that. And I showed how it was put forward in some very respectable academic arguments that I disagree with. Not at all clear that that's out of the picture. I think Trump what he did in effect is he sensed a ripple of hostility in the room towards him. That's not a surprise. Presidents should never sit in an oral argument. It's an effort to kind of coerce the judges, which is going to always backfire under these circumstances. And he should do it. The legal documents he put together were denounced immediately. In fact, they were denounced so fast that most people denounced them before they read them.
Right.
So one of the things that this amendment said was we're not going to try to undo the naturalization of people under the earlier law, which is a standard move in equitable courts in the United States. Courts are equitable courts. That is, they have some degree of discretion. One, and they basically said the strongest arguments against changing this what it has to do with people already here. They clearly wrote the brief before they read the opinion, and then they didn't change it because it came out the next day. I mean, that means that hats would have been prepared in advance, and they didn't want to do that. But right now, I mean, what happens is the attack is basically on the character of everybody who goes on the other side.
Sure.
I've gotten a little of this.
Of course you have. You're profiling courage right now. I mean, you don't even like Trump very much, okay? I've heard you enough to know that. You're standing here and you're going, this is a beautifully written EO. This makes a lot of sense. And then you go do your due diligence on your book and you find out, hell yeah, they're right.
Yes, I mean, it's a surprise, but me on Trump on tariffs, me on Trump on unitary executive, me on Trump on attacking the university. I'm on the other side of all those issues. I mean, look, the moment you have friends, you're finished as a scholar.
Right.
Is my And so you have to go through the world not trying to make friends. You don't want to make enemies, obviously, but what you do is if you think something is right, you just say it. And, when I wrote my book on takings, page 281 is a kind of minor corollary. I said, oh, by the way, the New Deal is completely unconstitutional. And you should have seen the response to that. Like a shaggy dog, this book will pass every passerby to give it a kick. All right. Well, who wrote this book for the Harvard Press? Why, this is a rag that should not have been published by anybody but some dumpster paper. You should have seen the reactions to the particular
Oh, my
book.
gosh.
I mean, and they were wrong.
Another stink bomb. You rolled right into the middle of everything.
Look, that's the way. Look, there's no point in writing something where the 88th person who defends position X.
Yes.
You write about those topics where you have a principled position to which everybody's opposed. That's the only way in which you can make your mark as a scholar. The whole point of this business, in a strange way, is you're trying to switch over dominant paradigms to another paradigm. And that's always been the model. So when I started to write about torts with a Roman law background, what I said is the problem with the American law of torts is it did not understand the Roman rules relating to corpora corpore, which is another topic which you've never spent a lot of time on. But it's a very sensible position. It says you want to figure out how you deal with injury. What do you start with? Simple cases, not hard cases, right? And the simple case is punching somebody in the nose. That's by the body to the body. And then you figure out how you extend that position. And that's called the lex equalia, on which you could do a real disposition. And that was my view about how American law ought to be reorganized. And, it met with a lot of disapproval. It was not so much political. But the people said, well, everybody's done it the other way. And I said, if it's done the other way, then you have to ask whether that's the right way or the wrong way. And so my entire academic career is being a little perverse. And now why is that, you might ask, apart from my warped temperament of mind? Well, the simplest explanation comes from the fact that I chose to have a wayward education, in the sense that, well, when I was in college, I told my dean I didn't want to major in anything. And he looked at me and says, you seem to do okay, so I didn't have to major in anything. So I then taught, took math, a bunch of things in all different areas to get some proficiency. And then when I went to law school, I went to England, not to America. And there, essentially, I learned a bunch of stuff that's not taught in this country, and I taught it to myself in my own way. And so that background, combined with the standard American background, meant that you had a set of tools, which is not commonly held by other people. And I, essentially, when I was 18 years old, well, I said, you're going to be an academic, I thought, and this is what you want to do. So this has been essentially a lifetime endeavor of following this strategy. And this book is perfectly consistent with my long-term sort of academic orientation.
I noticed that I know we're bumping up on your limitation here, but
No, you can take them down.
okay. Well, good. I mean, let's talk. I noticed that your book was blurbed by somebody who has been taken out of polite society by the Bar Association in California and the California Supreme Court. John Eastman, who's been on this program a couple of times as well.
Well, John is my student.
Oh, is he? Oh, okay. That makes sense.
One of the best students I ever had. John knows as much about this topic as pretty much anybody. He and I actually disagree on some of the fine points, particularly about the relationship of the English adoption of the birthright citizenship rule, which they did adopt, and the lack of its transformation into the United States. I actually just read the indictment, the opinion that was written in 2024. I mean, it starts off with a long discussion of John Eastman's views on the situation when Texas tried to block and get the recount in other states. And it was a very clever argument, and it actually has a lot of precedent, most of which lost and most of which was wrong. So the first case on standing, which is very much this kind of problem, is there was a statute called the Maternity Act passed in 1921, which gave benefits to individual women who had just been pregnant and gave birth to children, right? And you look at the standing clause, and you know what it says is just stand for purposes having to do with the general welfare of the United States. And the argument is that means you have to get public goods. You can't give individual payments to individual people. And so she's saying, so you got to stop this because you're not allowed to do it. And either I can stop you or this whole thing will go, because I'm not trying to get benefits for myself under a statute. I'm trying to stop the statute. And the only way I can stop it is to prevent you from giving the benefits to somebody else. And they were ruled out of court on standing grounds, and they were completely wrong. That was, in fact, a wrong decision. Well, that's what Eastman was asking for here, saying, look, I can't cure the problem of irregularities in other states by recounting the votes in Texas. So you have to look at those votes. And what happens is he lost the argument by a Supreme Court, which is congenitally unsympathetic to various kinds of standing arguments that expand standing. And I've written several long pieces why I think the Supreme Court is all wet on that problem. Because if something is everybody's problem and nobody has a special industry, then presumably somebody has to be allowed to stop it. And what the Supreme Court says, the moment nobody is especially hurt, it's now just a political problem, even though there's some real questions of ultravirus that is acting beyond the law. Well, that's what John was arguing. And what these people do is they try to refute the argument in their opinion in 2024. And they're wrong on the refutation. That is, they don't see the strength of what he said. And you look at this and say, well, this is the kind of thing that you would write in a respondent's brief to say this theory is wrong. And they're now using this stuff to say that the guy essentially has to be disbarred, but making an imaginative argument, which turns out, in my view, to be correct. John was a very clever student. And I mean, not only was he clever, he's a beautiful writer. And, you know, he was one of the dozen or so students or more that I had in 50 years whom you really knew had some genuine intellectual ability. And all of this gets completely wiped out in this sort of opinion. Now, he did not follow Epstein's rule, right? Because he got involved in
politics.
And you know, what happened, we're not good at that game.
It's unseemly too. I mean,
it's just wrong. So he should have, but of course, John, he had run for Attorney General in the state of California, but he had no chance of winning. And my guess is he kind of thought that Trump would, hey, maybe if he gets this thing for me, I'll make him Attorney General.
Maybe.
I don't know. But look, the basic argument, there are two arguments. One is no academic gets involved in a political dispute. And secondly, no political dispute should ever end up in court because everything gets messy. And that includes the various suits that were brought against Trump and the various suits that he's trying to bring against people on the other side of the situation, like Jim Comey. And if they're on fragile issues, it looks like a vendetta. And we don't need it on either side. The same thing with Netanyahu. This man, in the middle of the struggle for Israel, is answering questions as to whether or not he behaved improperly when he asked some people to write favorable stories about him in 2012. This is not what you want the fate of Israel to turn on.
Right.
So I basically have a strong view of partition on this, and it's rigorously bipartisan. And what's happening today is everybody thinks if the other guy is out of office and we could find a way to nail him with a judicial suit, we'll do it one way or another. And this is, go ahead.
Oh, I was going to change the subject on you because I wanted to find out about the leak at the U.S. Supreme Court. I mean, what do you make of that? And to the extent that we know, we make some assumptions on who we think did it.
Everybody makes the same assumptions, that there was no reason for any Republican to leak that. Now, there's this woman who writes for the Federalist. I forget her name now.
Molly Hemingway?
Yeah, she wrote the book. It was a scary book.
Yeah, I haven't read it yet.
Well, I'll just tell you the incident that she reported. The thing gets leaked, and you have to run an investigation. But who do you bring in? And they didn't get professionals. They had the Supreme Court staff to do this. But then the question is, when do you start to publish this opinion? And what happened is the Republicans wanted to get this thing out quickly so that the uncertainty would not last. And the Democrats wanted to draw it out. And then she says, I'm just quoting her, is that what happened is the Democrats agreed to a date by which they would get their dissent in. And by the way, it was a pathetically weak dissent, I might add. So what then happens is they get it in, but they throw a hooker. They drop a single footnote to a case that's yet to be decided by the court. And the rule is you can't publish one opinion so long as it gives you a hint about the outcome of an unpublished opinion that's there. And so that extended it a couple more weeks. Now you have to ask yourself, did they put that footnote in order to keep the pot boiling? Or did they put it in because it was utterly indispensable to the argument? Well, I think it's the former. And so what's happened is this is members of the Supreme Court weaponizing themselves. And she, I think, pointed it out. Now, remember, I'm a professor of law. I'm not a professor of facts. So it's not as though I went back and verified everything that she said. But if what she said is true, then this is a very serious breach of decorum on the part of the American left in the way in which it ran this thing. And courts ought not to do that stuff. I mean, the Chief Justice, interestingly enough, is really strong on this particular issue, on the question of how this thing goes. But what happened then was Merrick Garland, who was the Attorney General, refused to protect people who were suffered with death threats. Everybody in Maryland said no, and each of them said, oh, it's the other that's responsible for the jurisdiction and the defense. Well, I mean, you're sitting there and your wife is at home and these guys are parading at night and making noise and so forth, and they're afraid to go out.
Yeah.
Well, is this the appropriate way, or is this just a form of intimidation? And I regard it as the latter. And so I don't want to see anything like this happen again. And every time I hear that Trump is about to gear up another prosecution, as he is, right, I cringe because I think it's going to lead to the same thing in the opposite direction. As you're right, I said, look, I don't have any loyalty to any person. I'm an ideas man. And as you've noted, most of the things I've written about Trump have been against him, right? Not on the war, although I think he's botched it in terms of how you handle it. Because my politics are political oriented. I'm what you would call a libertarian hawk. And that's a position which says you don't use force very often. But boy, when you use it, it cannot be equivocal. What you do is you stop and go as a way to kill yourself. And Biden did that to Israel with respect to Gaza. And now Trump is making a complete mess of everything with Iran. Once you start to attack, you don't stop attacking until the other guy surrendered. And you don't sit there, let's take a pause and figure out what we can do. Because everything you say, Iran will act in bad faith and slow it up again. And the longer this thing goes on militarily, the more difficult it is to manage politically at home.
Well, I think he took the pause for the market.
Yeah,
to
but
catch
I mean,
up,
that's just wrong. But it's just wrong.
Well, okay.
I mean, in my view, you know what it is. You just shut them down. And you don't make pledges like we'll never use troops on land. I like to say when I was 13 years old, my late Uncle Albert, who had fought in the Second World War, what he always said about these kinds of military things is you cannot win a war from the air. You can do a lot from the air, and that's what Trump said he could do. What he really needed to do is to storm the beaches on Hormuz so as to control the highlands and the boats down below, if that was the appropriate military situation. I don't want to make a military judgment about anything, but I do want to make a political judgment, and that's a political judgment which says you do not put per se limitations on what you'll do at the outset of a value, because you're going to kill yourself. So when the United States, oh, we're not going to mine Haiphong Harbor, right, in the situation in Vietnam, that was a way to lose the war. Because, I mean, you had to go after these guys. And look, if I just saw last night, have you ever seen The Darkest Hour?
No, I haven't.
Well, go see it, because Lord Halifax, who's a decent man, he wants to form a compromise, make a deal before Dunkirk. And Churchill, after much agony, turns him down. And could you imagine making a deal with them? If you're on the losing end, it's terrible. Now, suppose what happens is you reach the German border and the Germans come forward and say, well, we'll get rid of Adolf Hitler if you allow us to retain the Nazi party as running the country.
Right. Exactly.
Well,
that's the way I feel exactly what's going on in Iran. Yeah, we got to get rid of those bastards, as far as I'm concerned.
Well, I mean, they're very tactfully, that's the right answer, because they are, as you said, bastards.
They're Nazis. They're terrible.
They are basically perpetually in bad faith, because the definition for bad faith for these purposes is you negotiate with the intention of not entering into an agreement. And that's what's happened, because the closer they get, they then add a new condition, right? And when you add the new condition, it slows everything up. So now all of a sudden, peace in Hormuz involves dealing with Hezbollah and with Gaza and so forth. It's the wrong way in which to do things.
Yeah. I don't know how all of a sudden Israel's relationship with Lebanon came into it, when it's really the relationship with Hezbollah that this is an issue of. And why are we negotiating that? And why is everything we're doing contingent on that? That makes no sense. So in that way, it's metastasizing just a little bit to preposterous proportions.
So, and also, by the way, it gets rid of the temple promises that Trump made. He's making a mess of it.
Yeah.
And
I don't necessarily ratify that, but I would say that there are some missteps here. The one good thing he's doing is he's continuing the blockade, which I think is good. I mean, just bleed them dry then. Okay, guys, you figure out who's in charge here, and nobody knows who's in charge there. You guys figure it out and then get back to me. Meantime, the blockade continues.
Well, that's right. You could always negotiate while you apply force. You can never pause. And so when people wanted to have a ceasefire back in Lebanon, in Israel and in Gaza in October or November of 2023, it was just a terrible mistake. You always have to ask, who is that going to help?
Yeah,
and the
exactly.
answer is it would certainly have helped Hamas relative to the Israelis. What Joe Biden should have said is, you get this finished by January 1st, 2024, and we'll be very happy. But he didn't say that. He said, we're always worried about mutual escalation. There's only one way to beat the problem of mutual escalation. You wake them to the position where they can't reply militarily. It's the only time that you could reply incrementally is if you're given an incremental attack. So the single dumbest words in the history of negotiation is when Joe Biden's staff tells the Israeli, take the win. Remember?
I didn't remember that.
That was
I'm still stuck.
They had that little discussion about the fake attack, missile attack that the Iranians ran against the Israelis. And the Israelis won the exchange. He said, take the win. Because they thought escalation would be terrible. And what the Israelis did is, by this time they had their fill of Joe. And that's when they had all the stuff with respect to the walkie-talkies and the pages and so forth. And they blew up the leadership. And they were right to do so. I mean, they may hate Netanyahu, but if they had somebody like Joe Biden running Israel, that country would not be existing anymore. They would be basically beaten to death by attrition, either by attrition or by sabotage or something.
I agree. One last thing on the 14th Amendment and your book. If you had your druthers, who would you like to write that opinion? We both think John Roberts is probably going to do it.
Well,
who would you prefer?
My guess is I would probably pick Alito. Gorsuch is a friend. He's a very smart man, but he's an oddball, right?
Yeah, Yes.
You remember some of the opinions he wrote?
Yes. Yes.
And so there are too many surprises with him.
Yeah.
Roberts can't write it. I don't think Kavanaugh has enough conviction on this particular issue. I think he's more interested in being number 5 on the left to right spectrum. Barrett, again, I mean, she did the silly thing that we read with respect to mental states of infants. And again, I think she's somebody who's instinctively looking for a compromise when you don't want a compromise.
Yeah, she's kind of a technocrat too. I mean, she's
Yeah, there's a bit of that now. Thomas, no. The reason about Thomas, I mean, this man, he has personalized segregation too much to be an independent party. You should read the speech that he wrote at the Civitas Institute. It was a powerful speech, but it was a deeply personal speech. And deeply personal speeches don't give you the right offer. You have to have a certain detachment in order to write.
That's the only negative. That's the only negative thing I've heard about that speech. I shared it with my Facebook.
Well, I mean, look, he and I have very different conceptions of what's natural law. And that's another thing that I've been writing about since 1989. He tends to have an intuitive natural law theory. I tend to have a highly utilitarian one. And this starts with reading the Roman text and trying to figure out how they go forward.
What is the basis for natural law? I've been asked this before. I just want the expert in the world to tell me.
Well, I would tell you essentially the place you have to start is with Gaius 1:1, and the parallel provisions is Justinian. And what he says, there's certain principles that are developed, that are followed everywhere throughout the world over time and at a given time across countries. He says those are the principles. And then what he does is he makes the critical move. He says there are natural principles about relationship, marriage, contract, sale, and so forth. But there are also a set of formalities. The only thing that natural law regulates are the fundamental relationships. Local customs regulate the way you enforce them. So, for example, a contract to sell land is different from a contract to sell a newspaper because the land is going to last forever. And there are going to be questions about the state of the title after the original parties have died and somebody else has taken their place. That's not a problem with the newspaper. So there's nobody in the world who ever thinks that you can do a successful system of land transactions unless you have a system of formalities. And these formalities have to govern two things. One is they have to let the parties know that the deal is on. They're not just negotiation. And it has to give notice to the rest of the world so they will know that the buyer is the new owner of the land and you don't want to do business with the seller. And so you then go back to the first of these ceremonies called Mancipatio, transferred by hand. And Gaius in Book 1 explains how it's done. And you look at the definition and he basically gets it right. But the point is, if you're in a desert country, you can't use what the Romans used. If you're in an igloo, you may do different rules. So the formalities vary all the time from places, but the fundamental notion that you have to translate and from A to B is one that kind of goes across all these societies. Well, okay, then how do you do it? Well, if you're in England, you don't have this funny ceremony. What you do is you have a deed, which meets the requirement of the statute of frauds, and then you have a recordation system where the two parties put their title on so the rest of the world knows it. Those systems can vary from nation to nation and place to place, but the notion that you need to have a sale or a contract of hire or a contract of marriage does not. And then what I did is I wrote this book called, On the History of Natural Law, and the standard objection to it is that the systems that you see everywhere around the world are so varied one from another. How could any of them be natural? Well, that's true with respect to formalities, but it's not true with the definition of fundamental relationships. And then what I do is I go through the Roman text, because that's my field, and I deal with all the cases where they start to use either natural reason or natural law and see what's the uniformity of these particular rules. And it turns out it's extremely powerful that the rules that they take are always ones that last. So you've heard about land and you've heard about water, right? You know about those two things.
I know about those things.
Yeah, you're a real expert. Well, do you know that the legal regimes that govern water are completely different from those that govern land? So in water, essentially, it's a situation where everybody has to have access to running water. In land, the only way to develop is that you have exclusive title to the particular piece of land that you get. And well, does this matter much? Well, what you say is, well, let's reverse the rules and see what happens. So all of a sudden, somebody make exclusive right of water, and what does he do? He dams up a river and puts it into a well, and all of a sudden, you don't have river transportation, you don't get river fishing, you don't get river bathing, you don't get river as a source of land for everything else. It'd be absolutely suicide. And so the rules always say, as a first approximation, open access to all. And then, like every system, what are you going to do when there's too much access? People overuse it. Well, then you have to have a government, because there's no private party can do it, which can dredge and fill, for example, or put slippery shipping lanes into place so boats don't kayak, and then do it with respect to land. And let's use the water regime. So you go on the land, you plant something, I come on the land, and I take it away. Well, by the time that's done, you have no agriculture, because the shift from a hunter-gatherer society to a landed society means that you have to be able to invest today in order to be able to harvest tomorrow. And you can't do that under an open regime. So if you reverse the two rules, right, the whole society would fail. Now, what's the importance about that? Most people who do natural law theory are very skeptical of utilitarian explanations. But in fact, it's the only thing that explains these systems. And then the way it emerges is you put it into place, is watch it work, see where the defect comes, and then you patch the hole. Because what you need to do is to realize, for example, as the volume of traffic starts to increase on a river, you need more government controls. And as the number of people that want to come on property and so forth, you may need to have various kinds of protections around the perimeters to keep them out. And you go through all of this stuff, and every time you come to something which they call the natural rule, a natural rule on self-defense, the natural rule on the acquisition of various kinds of animals, the natural rule on the taking care of children and all the rest of that stuff, you look at them, these rules are not close. Adopt this other rule and the whole thing breaks down. And so natural law is attacked because of its confusion on formalities, whereas you actually look at the substance, it goes. And not only that, as I did in these articles, I said, if you understand how the private law organizes, then you could understand how the public law is organized. So to give you the first example about water rights, one of the great American cases, Gardner against the city of Newburgh, or the village of Newburgh. It was Chancellor Chenta, a truly great mind. And what happened was that the town diverted water so that everybody below could not get any, and those lower riparians sued. There was no statute on the books at that time and no constitutional provision. And what the justice said, this is against natural justice, because when they basically divert the river, they're wiping everybody else out. And we can't let the government do what a private party could never do, which was to universally divert the river. And so what happened is all of a sudden, land and water rights now become in sync in terms of their constitutional protection. And the book I wrote on takings was designed to say, if you take this seriously, one idea and run it through, then you can start to figure out when the government has taken property or not. So there's a very famous case called Willow River. And this is about a river. And people have dams on rivers, right? So the water has to be able to fall to make them work. And what the government does is it raises the water levels so that basically you can't run your mill. And the argument that was made by the upper riparian is, you've taken my power source. You can't do that. It's a taking because a private party couldn't do it. And Justice Jackson did the stupidest thing imaginable. He's a great justice. And he said, look, the government has got rights that ordinary private individuals can't do. So no private individual could raise it, but the government could raise it. At that particular point, it's just outright theft by the state.
Sure it is.
Now, why does this matter? Because that passage then goes into the famous case called Penn Central, in which the same problem, what the government can't do, what other people can do unless it pays for it. And you have air rights, which are buy and sell, worth millions of dollars. And Justice Brennan writes a funny opinion saying, well, the state could prevent you from building, even though if a private party was prevented, they'd have to pay. And what opinion did he rely upon? He relied on this dumb water rights opinion that Justice Jackson had written some 20 years before.
Was that
So
the
the
little pink
whole
house
theory
one?
goes all the way through.
Mm-hmm.
And, I don't teach any one course. Whatever anybody asks me to teach, I will teach, because that's the only way you could learn. But having done all of this stuff under that plan that I started when I was a kid, the great advantage is you have many powerful illustrations from many different fields. And that gives you a better chance of synthesizing the whole thing into a whole.
Richard Epstein, a great honor to get this clinic from you today. The clinic is contained in this podcast, but also in his book, The Myth of Birthright Citizenship, what the 14th Amendment Really Says. Richard A. Epstein, you are a treasure in America. God bless you, and thank you.
My pleasure to be with you, and thank you for having me, Victoria.
Thank you. And hang in there. I want you to just sit there for just a couple of minutes until you're uploaded all the way through. That's just calling an audible to this great man. I really appreciate it.
Well, I understand that we would hate for these words to disappear into cyberspace.
Yeah, that's exactly right. Thank you, sir. Yeah, that's amazing. Well, what'd you think? That was pretty cool. I've always wanted to talk to him. Not because I felt like I could converse on an equal basis, but just because I wanted to say, and then what? And what do you say about this? Which is what I got to do today. So mission accomplished for me. And book is terrific, and it's coming out, and I'm going to get my copy. That's pretty cool. We have gone a little bit of overtime. As general, there is no overtime for this program. We go as long as we need to. But I did want to say that we will come back to the issue of the SPLC. We will do that. That is very troubling. We'll see if they fill it out a little bit more and give us a few more names, just a few more details from the DOJ. We'll see how this goes. And thank you. Appreciate it. And don't forget, we'll be back here on Tuesday.